Good morning. I'm Benjamin Sanchez coming to you today from Houston, Texas. I'm a lawyer and I've been doing this for 22 years. For my entire 22 years, I've been involved in debt litigation. For some of those years, I represented banks, mortgage companies, debt buyers, and other creditors. For the past 7 years, I've been representing consumers and debtors, tenants, and homeowners. Today, I want to discuss with you the number one mistake that most people make when they are sued for debt. The number one mistake that most people make when they are sued for debt is exactly the same thing that most tenants make when they are sued for eviction. And that is simply this: they don't answer. They don't answer the lawsuit and they give the creditor or debt buyer an easy victory. Not only a victory, but a victory in the amount that the lawsuit is for, even though the creditor may not be entitled to it otherwise. So many times I've had people come to me years after they've been sued and ignored the lawsuit and tell me that the creditor is now garnishing their bank account, that the creditor now has a writ of execution out there trying to take their things, that the creditor is now asking questions in writing and wants to put them under oath for a post-judgment deposition. And they don't understand how it got to that point, or even if they do understand how it got to that point, they are hoping for some sort of miracle. Now, sometimes I can help those people. It depends on how long they come to me after the judgment, and it depends on what happened when the case was originally filed and the judgment was obtained, because there are mistakes that creditors make in getting judgments. But the easiest thing that people could do, that they don't do, but the easiest thing they can do is simply file a written answer with the court. That answer doesn't even have to be fancy. It just has to be something that indicates to the court what case it is, who you are, and that you deny the debt. Okay? Now, there are some exceptions if the creditor has filed the case with a sworn affidavit. In that case, the answer must be sworn as well, or it may just be considered not to comply with the rules. So, obviously, an attorney can help make that process easier. But at the very least, if you or someone you know is sued for debt, file an answer that indicates the case, who you are, that you generally deny whatever allegations are in the petition, and then swear to that under oath. And if you do that timely, within the amount of time that the citation tells you to file an answer, and you file it correctly with the right court, then at least you will avoid a default judgment and you will get notice of any future hearings or trials. Those are a lot of steps that you have to do to make sure you do it right. But please do not ignore the lawsuit. 90% of lawsuits for debt are won by default judgment because people simply ignore the lawsuit, either because they hope it will go away on its own, which they never do, or they just don't know what to do, or they're just too scared or worried about the consequences of the lawsuit. An attorney can help you with that, and we'll discuss that later in the week. I hope you have a great week, everybody. Remember, answer the lawsuit, answer the lawsuit, answer the lawsuit. Have a great day. Bye bye.